a man who's apparently broke his hip and a nurse who's Facebooking instead of helping him, because he's in a box and that it's eventually going to fill up with water and something bad's going to happen. Does it meet the 4 requirements that are necessary for negligence? Did the defendant, in this case, who's the defendant? The Facebooking nurse, right? Oh, the plaintiff, man with broken hip, a legal duty of care. Yes, I believe that if somebody is designated to take care of an elderly person, they owe them a duty of care for some things, yes.
I read in the newspaper a case like that. It was like a mom or a babysitter getting like a little bit of that and they wanted to Facebook why they were in the bathroom.
Yikes. I better let my wife know that. Yeah. So there's plenty of examples of people who are charged with taking care of children, whether it's parent or babysitter, and they're off doing something and not properly supervising them. So I suppose they would have liability. Again, separating tort from criminal liability, I mean, there was a recent case where a kid was at grandma's house, and the kid got into grandma's medication and died as a result of ingesting that medication. And then the question was whether the person who was responsible for watching them and the person who had the medication laying around should be responsible. So yeah, I mean, each one of these facts, the first question is, do you owe that kid a duty? I would say yes. I personally had a situation with this because my kids are always trying to kill themselves. One of my kids liked to play with windows in the house. And so I removed all types of things that would prevent the kid from climbing up and trying to get out the window. And one day I turned my back for a moment while my wife wasn't home. I was responsible for supervising him. And he put something up against the window, stepped up on it. The window was open, the screen was on, and shoved the screen and went out of the house. Now, when we were first building our house, I think my cheapness saved his life. We were trying to figure out, it was a ranch, we were trying to figure out if we were going to dig out the front of the house and have like a, daylight basement where you could see out the basement. And I decided, that cost too much money, so we didn't do that. So if we had, he would have fell out 2 stories, but because of me, he just landed on a bush outside. He was fine.
How old was he?
He was young. I mean, he's old enough to get up, to step up and shove out. Well, now I've figured out that what you do is you open the windows from the top. So if you want to let air in, you open them from the top, and then the kid can't get up. But anyway. So I quickly ran out. I mean, I ran out so fast I almost caught him on the other side. And then I come inside. I'm like, should I tell my wife? What do you guys think? So I thought, well, if it was the other way around, I'd want to know. And everything worked out, so why not? So I called her, and I'm like, you won't believe what happened. So she's like, oh, brother. And the next day, we're out riding our bikes or something, and the neighbor lady who's out in the middle of the road, she goes, how's your son? And my wife goes, what do you mean? She says, I watched him fall out the window yesterday. I wondered if he's okay. So it was a good thing I told her. But, I owed a legal duty to him, my son, and, I'm not supposed to stand there and go, hey, if you're going to be stupid, go ahead and do it, right? And I breached that duty by not preventing him from going out the window. He didn't have an injury, though, so that was good. All right, so in this situation, the nurse owes him a legal duty. She breaches that. I mean, her duty isn't just take care of him, but if he comes in a situation where he's placed in harm's way, she should be there. She should be responsive. She's not, because she's on Facebook. And there's many, many situations where Facebook's cause injury or death, right? Indirectly. like people Facebooking while driving. Yeah.
So, I just got one comment.
Just one? Okay.
For instance, you in a, let's say, police, happen to be involved in a police shootout, you know what I mean? And the police duty is to protect people, and you end up getting shot.
Right, so not so much the police and there's some criminal liability, but what liability does law enforcement have to protect citizens from getting shot in a shootout? Yeah. Right, they always depict that on TV, right? You know, somebody starts running and the police just whip out every weapon they have and unleash it on crowds of people and things like that. But yeah, I think many law enforcement agencies have been sued by people who get shot as a result of some kind of shootout. And they could be in a drug house, they could be walking down the street, they could be in some situation where law enforcement is responsible for containing a situation and it gets out of hand and law enforcement make a decision and they get harmed by it. So yeah. Now there are some arguments that the government has some immunity if they're acting within the scope of their power and somebody gets harmed in the process. So, I mean, I can't go a lot further than that, but that would be the argument. And then, did he suffer illegal injury? Yes, he did. And was her actions responsible? Now, this is the tricky one. Right? Because what's she going to say?
No,
I didn't shove him. I told him to be careful. There are handrails in there. He never said anything to me. I didn't hear him. So just the fact that I'm on Facebook doesn't mean I'm automatically liable. My actions in Facebooking did not cause his harm. So I guess the question is, you know, what types of injuries did he sustain? And is her inattention the result of additional injuries? Because she might be successful in saying, I couldn't have prevented it. But the issue is if he just stays there and something continues to happen to him while she's off not paying attention to him. Or maybe the issue is if she had been there and properly supervising him, then this wouldn't have happened in the first place. So those are a couple theories. Question, comment? Or were you?
Yeah,
Oh, okay.
what about how far away was she from the shower?
I don't know.
Oh, okay.
So bed, shower, and she's all right. So she's there. She's around. She's actually only like what? 2 feet, maybe. She's not far away. I'd sue over that tiny bed. I mean, come on. All right, so that's what you need, and we'll get into each one of these elements here. But that causation, did her actions cause his harm? That's probably the real question in this case. Now, as we look at each one of those elements, the first one is, you know, in most cases, we owe a reasonable duty to care to act in the circumstances. So her duty would be watch him the best she can. He doesn't want her in the shower with him, right? And anyway, and now I forgot where I was going with that. But if she's not, you know, did she respond in a reasonable way? I mean, she's not far away. You know, she's got headphones on, or she's Facebooking, she's not paying attention. A reasonable person under those circumstances probably would have responded and helped him and prevented his injury. When you think of it in the business context, you know, do business owners have a duty of care to people who come into their business? And sometimes, like when I ask this in my online courses, like debate over whether they buy in something or not. Generally, no. If you invite the public in, whether they buy something or not, if they're on your premises, you owe them a duty to make sure that there's not something unsafe. So one scenario I like to use online is what if somebody comes in your store, small store, and you get a phone call. And so, there's boxes everywhere, and the person's elderly, and you run off to answer the phone. Well, what duty do you have to them in your store? Make sure it's safe, right? Not boxes where they can trip, make sure they're not going into areas they shouldn't be. Maybe answer the phone so you can still see them, talk to them. Now, if there's some obvious risk, then maybe you don't have a duty to tell people of that. Now, so often that's a case-by-case thing, because what one person might claim is obvious, someone else might not claim. You see those signs that say the floor's slippery, wet. Some people might make the argument, well, that's obvious. It's wet, it's going to be slippery. But do you always know? You don't always know. Duty of professionals, a little different than just a reasonable person standard. If I'm an attorney and then somebody asks for my representation, I shouldn't go, oh, sorry, I messed it up. I'm just, the law's so confusing, right? It's complicated. I don't understand it, right? I'm held to the same standard as other attorneys, not just any person on the street. CPA shouldn't say, well, I'm not that great at math. Taxes are confusing. I don't really get them. So they're held to the standard as other CPAs, or doctors are held to the standard of other doctors. The injury element. It has to be a legally recognizable injury. We talked about that a little bit already. I mean, if somebody's feelings hurt by something somebody said, that's probably not going to be sufficient to be an actual injury. Note the second bullet. Now, this will trick people. It's not intended to. But if there isn't any injury, then there's no negligence, because one of the elements is missing. Like in that scenario, that YouTube video, if a person had run a red light, but nobody got hurt, nobody got hit, it might be a violation of a statute that says you're not supposed to run red lights, but it's not negligence. Some people have a hard time with it. Like, isn't it negligent to run through a red light to not pay attention? No. It's only negligence if it has all the elements, and if no one's injured by it. It's not. Might be irresponsible. It might be a violation of a criminal statute or something, but it's not negligence because no one got hurt. And so if somebody is injured, they would be entitled to damages, either compensatory or punitive. We talked a little bit about that. Usually not punitive unless it's some type of intentional act. Like in that YouTube video, what would be an intentional act? Right, like somebody could say, you don't have the right of way. What are you doing, walking across there when you're not supposed to be? And then gun it and teach them a lesson. Probably would be sufficient. All right, causation. This is the tricky one, because that causation is not a word that comes up that often in conversation. There's two parts to causation. To hold the defendant liable, a plaintiff has to show that the defendant's tortious act caused their injury. And there's causation in fact and proximate cause. The first part of the test is, but for the defendant's act, the injury would not have occurred. So think back to the video. But for the person running a red light, that series of events would not have occurred. The second part is whether it was foreseeable that when they ran a red light that they might get hit, and that might have injured somebody who was walking across the street. I'm going to tell you an embarrassing story, kind of something that happened to me, but hopefully by sharing my mistakes you won't repeat them, and you'll see an idea of negligence. I used to live in Kalamazoo, and I would commute back and forth to Grand Rapids, and I had what I think this might be a generalization, but I think more of a male characteristic. I like to see how far I could go without getting gas. So my wife will say, honey, it's on empty, and I'll say, oh, no, it's not. Right? Because I know there's like this additional mileage you can get. That's just like more of a suggestion when it says you're out of gas, right? You know, the whole hassle of stopping in the middle of your trip to get gas. So occasionally I would run out of gas, and there isn't much between Kalamazoo and Grand Rapids other than Wayland, and what is that? And so I got this idea while I was in Wayland. There's a Tractor Supply store there. I'm going to go in and get a gas can, so if I ever run out of gas, I'll, fill up. And I'm in there, and I see this really cool thing. It's this, like, metal can. I don't know, it's like for tractors or what, but I thought, well, gee, I can fill that up, right? Because you don't want to drive around with a plastic container of gas in your vehicle, right? Fumes and explosions, those are bad things, right? Did you ever think about that? Like you run to the store to get gas in a container because your lawnmower's out of gas. You're now driving around with a bomb inside your car. So anyway, I got this idea. I'm like, I remember seeing safari shows where like Jeeps, because I have a Jeep. It's not a real Jeep. It's a Jeep Liberty. It's a girl Jeep. But so I got this idea. I'm going to strap the gas can on there. And I get home and I realize a Jeep Liberty has a spare tire in the middle of the back. Couldn't get it on, so I put a little shelf on the front, put it on the front. And I'm driving into Grand Rapids. This is months later. And there's an accident on the other side of the S-curve. What happens when there's an accident on the other side of the S-curve? Both sides slow down, right? And I wasn't anticipating this, so people in front of me jammed on the brakes for no reason because there was an accident and flashers, woo, on the other side of the highway. And I kind of ran into this lady who was in front of me, well, her car, which caused a little bit of a fire. And she wasn't burned or anything like that, just the back of her car got a little smoky. And so, this part didn't happen, but what if she sued me for negligence? Well, is it an intentional tort? Did I strap on a gas can and go looking for old ladies? No, right? So it's not an intentional tort, but was it foreseeable? That's the second part of this test. When I strapped on the gas can, my mindset is, if I run out of gas, I got gas. But was it foreseeable when I put it on there that I might actually have an accident and cause a gas spill or explosion? Yeah.
So does it have to be foreseeable to the plaintiff or just the average human?
No, not foreseeable to the plaintiff.
Or to the defendant?
The defendant has to be reasonably foreseeable. So not the you have to prove that I actually knew in my mind that I could hit an old lady, but that to a reasonable person with common sense, they should have known that this could happen. So what do you guys think? Yeah, I'd say so. I'd say that could happen. That's why they don't make vehicles with that, right? So proximate cause also has to do with how strong the connection is. Well, in my scenario, I hit her directly, and it causes damage to her vehicle. I think that's a strong enough connection. What about vehicles right around her? I'd say so. Like, even though I don't know it's going to happen, if it does, if she runs into another car or the fire gets a little out of control and catches some cars around it on fire, I think that's sufficient. This part didn't happen, but let's say some radio station picks up the story of some dumb guy who catches a lady on fire, and it goes national. Some guy in some other state is driving, hears a story, laughs so hard, dumps his coffee in his lap, burns himself, and crashes into a tree. Can we establish that but for my negligent actions, he wouldn't have a burned lap? Yes. But it's not strong enough, right? There's no way I could have reasonably foreseen that my conduct would cause some guy in another state to burn his lap area with coffee, right? So, do you guys think I actually did that? Like one semester I told that story and I had a student who followed me around, like trying to see if my Jeep was burned or something. It didn't really happen. There's enough of my stories that come from actual cases in my life that some people believe they happened, but it didn't really happen. I did hit an old lady, but not under those circumstances.
It was intentional, so it wasn't.
When I was young, this is like 50 years ago, but I had a LTD police interceptor. That was my first car. This thing was awesome, man. It was awesome. It would take a while to get up to speed, but when that thing got going, nothing would stop it. So I was late for work. I worked at Kentucky Fried Chicken. And I'm going down this hill in the wintertime, and this woman, elderly woman, forgets where her driveway is and jams on her brake right in front of me. I wasn't stopping for nothing. I hit her so hard, picked up the car, twirled it around. She ended up on top of a snowbank. So I get out of the car. So this part really did happen. So I get out of the car. I go jumping up on the snowbank. I'm like, oh, crap. She's gone. She's not in the car. Then I look and realize I hit her so hard the seat broke and she's laying down in the vehicle.
Was she okay?
She was. So some guy in a pickup truck comes up behind me. Officer, I saw the whole thing. That young man. Sorry. The worst part was later. I was in the store downtown, and I knew the owners of the store. And all of a sudden, the door rings, and they turn and they go, "Grandma!" And I look, and this is the lady I hit with a neck brace on. So I kind of got down and crawled out of the store. But okay, I might have made that part up. No, that really did happen, but I didn't crawl out of the store. I asked him later, "Is she okay?" He's like, "Yeah, some stupid guy hit her." So that's negligence, right? I mean, the argument that should somebody be stopping dead in front of you because they forget where their driveway is? No, but it doesn't matter. Like once you set certain things in motion, you're going to be responsible for them. All right. Defense is the negligence. So this is the argument that, okay, maybe I was negligent, but the defendant, maybe they have some excuse. Maybe I have some excuse for what happened. One is assumption of the risk. When you go to a sporting event, for example, because we have a sporting situation up here, what kind of risks do you take on?
Getting hit by a foul ball.
Right. What kind of risks don't you take on?
Tackled by one of the players.
Right. So you're at a basketball game. Maybe you're sitting, down low and a ball whaps you in the head. But if a player comes up in the stands and beats the crap out of you, that's not the type of risk that you should take on, I suppose. You're at a car race.
Yeah, what if he threw beer at him?
Well, I mean, I suppose there's the argument that you were defending yourself, but if something gets thrown at you, maybe there's something else you could do to defend yourself other than go find the person and beat them. The wrong person, yes. Whoops. So, I mean, I think that there are, basically the rule is you assume the type of risk that you know about, but not more. Like, did we use the Mike Tyson example last time? Like, you assume that you might get punched by Mike Tyson, but not have your ear chewed off. All right, superseding cause. I just like saying that. There's negligence going on, but the injury ends up being caused by some event that intervenes. I like to use the example of you're on a boat with not enough lifeboats, and before it goes down, you're struck by lightning and it blows up. Like, maybe there wasn't enough lifeboats, but it doesn't matter. Right? Something else intervened and actually caused the injury or harm. Contributory versus comparative negligence. This is an argument that, well, maybe the defendant was liable, but maybe the plaintiff was too. In most jurisdictions, they use comparative negligence. A few jurisdictions use contributory negligence. That theory is if the plaintiff was responsible for their own harm, then they don't get to recover. So back to the scenario with a PT Cruiser, as you pointed out. They're walking somewhere they should not be walking. In some states, too bad. Even if they're only a small percentage at fault, they don't get to recover. Most jurisdictions do a comparison here. And read it very carefully. As long as the plaintiff, the person who's suing and saying they're injured, is less than half at fault, then they do get to recover. Their recovery is just reduced by how much they're at fault. Now, I have no idea how juries would figure that out. Like, dark clothes outside the crosswalk equal 30%. I don't know how that math formula works, but if they say, if they generally, they weigh and they go, plaintiff's less at fault than defendant, but we're going to reduce the plaintiff's recovery because we think they were a certain percentage at fault, a lot of jurisdictions will allow them to do that. Here's an example. A guy goes to a bar, he drinks too much, gets in his pickup, is driving down the road, ends up veering off the road, and as he veers, the axle on his truck snaps, which causes a rollover accident. He's not wearing a seatbelt. He gets thrown from the vehicle and becomes a paraplegic. Sues the manufacturer of the vehicle claiming that it had a defective axle. And in fact, it did. They were able to show through testing that the axle was defective and should not have snapped, but did. Now, the reason it did was because of his response to whatever. He claimed there was a deer in the road. The manufacturer's theory was he was drunk and fell asleep and woke up, and when he did, he overcorrected, and that caused a series of events. The manufacturer also argued if he'd been wearing a seatbelt, he wouldn't have done those other things. What do you guys think? I mean, can't you see all the variables here and the fact that it's not just your axle is defective, you caused my injury, I get to recover everything? Should have been wearing a seatbelt, shouldn't have been drunk, and shouldn't have drove in a way that caused the axle to snap.
I think you should get charged with DUI and seatbelt, but still the axle was broke.
Well, we're not going to talk about crimes, right? Because we're just going to say, should he be able to recover anything for being in a wheelchair now?
Did they prove that he was drunk?
Mm-hmm. Yeah, they came on the scene. He was intoxicated and severely injured. So, do I? Doesn't matter. Like, people ask that in crimes, like, well, do you think OJ did it? Who cares? Right? What I think doesn't matter at all. He wasn't able to recover. The jury said, it's sad that somebody ends up paralyzed, but the jury wasn't going to reward him for how it happened. Right. I mean, if there's any way to substantiate that he wasn't intoxicated and there was a deer, and that he could not have foreseen the axle was defective, and maybe he was negligent. Maybe, what do they tell you when a deer, The commercial where the Allstate guy comes prancing out into the road, and what's supposed to happen when he does? You're supposed to stop. No, just hit him, right? You're supposed to do what? No, I don't speed up. Maybe that's not. But not. They say don't just jam on the brakes or just overcorrect and end up causing a worse accident. Hit the deer.
Yeah, and say
Right.
I have a CDL out there for a couple of professional companies, and
Mhm.
they always told us that the safety briefings, if something like that happens, hit the accelerator and it raise up the nose of the truck.
Well, I don't know if I'll go. Sure,
Yeah.
you're a professional driver, and there might be rules about that. But I mean, I would say that in a truck, I think you're going to win a truck deer fight. So, but in smaller vehicles, maybe the best idea isn't to speed up, but isn't to lock up and veer into a tree either.
And their reasoning behind it was because if you hit your brakes, you're
Right.
burning down.
Yeah, that makes sense. Yeah, I know lots of people who've had deer come through their windshield. Well, not a lot, a few people. But I know a guy who was driving down the highway, and a truck lost a tire, and the tire went through the car.
Gators.
Yeah. All right, so that's kind of what we're doing. Now, I don't want you to miss this, right? You guys kind of get the formula. As long as the plaintiff isn't more at fault than a defendant, they get to recover, but the recovery is reduced, right? This means, the flip side of this is, the plaintiff gets to recover even if they're only a little bit at fault in a comparative negligence jurisdiction. But if they're only a little bit at fault in a contributory negligence jurisdiction, what do they get? Nothing. So what the law is in your jurisdiction really matters. All right, and here's some other doctrines. Res ipsa loquitur. Remember, I wouldn't say I was going to give you much Latin, but you should know this term. Res ipsa loquitur means the thing speaks for itself. There must have been negligence. Right? These things just don't happen without it. You go in for surgery. You come out with the wrong thing missing. Happens a lot, right? Now they have you mark the spot. Like, what are we doing here? Put a mark on that. Make sure I remove where the X is. Or you come out of surgery, everything's fine. Weeks later, you have a sharp pain. You go in, realize that you have scissors and cotton balls and stuff inside you. Right? You weren't awake when it happened, but it must be negligence because you weren't born with those things in you. Right? So the thing speaks for itself. Somebody was negligent. Or negligence per se, which means on its face, which means if these things happen, if you can show that there was a specific law or statute was broken and you fall into a protected category under that statute, then you're protected. And it's negligence on its face. Yeah.
The story I heard, there was the Air Force gentleman who was having gallbladder surgery.
Mm-hmm.
The surgeon who was taking out gallbladder missed.
Well, wow, I don't know about all that. There's certainly a variety of things going on there from, is it malpractice to are there certain risks associated with surgeries? Like if you've ever had surgery, they tell you, this could happen, this could happen, this could happen, this could happen. You're like, oh, really?
Yeah, the thing about it was his unit was getting ready to deploy overseas.
And he didn't get to deploy as a result.
And the thing was, they told him, it's like, you either have this surgery and get your gallbladder out, or you're not going.
And he wasn't going either way. Yeah. And then there's the whole idea of whether a governmental actor, has absolute liability for what they do. So I don't work in that I've never taken on a medical malpractice case involving a military doctor, so I don't know. But I'm betting there's lots of case law on that, where people go to those Army medical centers, and a doctor does something that's would be considered malpractice. What liability do they have, and does the military have? Often it comes down to whether they're acting within the scope of what they're supposed to, or doing something crazy. All right. Danger invites rescue, or a closely related doctrine is attractive nuisance. A scenario is created where somebody's going to try to help you, and as a result of helping you, they get harmed. Or you've got something that draws people in, like kids, swimming pools, things like that. All those things could affect negligence. And then, another one that commonly comes up is what dram shop acts, usually there's statutes that have to do with what liability servers of alcohol have. So one question is, if somebody drinks and goes out and does something as a result of it, they certainly have personal liability. This is a question as to whether others who serve them have liability, and it's not necessarily limited to bars. There's all kinds of questions about if you're at a party or at somebody's home and they provide alcohol, whether they also have liability for that too. I'm not going to answer all those, but I told you I wasn't going to answer that. So generally, the question's going to come. Like somebody came in to see me and they asked me, hey, I had a party at my house. Somebody left my house and there was an accident. Do I have liability? Well, based on everything we've talked about in this class so far, what kind of liability am I going to start looking at? We've talked about criminal liability. We've talked about civil liability, right? So I'm going to look at tort law in that area. So in that jurisdiction, what responsibility does a person who serves alcohol at a party have to people who consume it and then go out and do something? I'm going to look at what statutes there are. Like if there's a statute that says you can serve alcohol to other people in your home, but if you do, you're absolutely liable for whatever happens when they leave. Super Bowl party, Super Bowl, that's coming up, right? Right, that's football. What liability does somebody have in that situation? So I can't answer it in that situation, but that's what I would start doing, is looking at what are the laws that might expose my client to liability in those situations, both criminally and civilly. All right. Now, strict liability. How much time we got? What time is it? 20 minutes. Awesome. I think I can do it. So, let's look at that example over there. Strict liability means, you're going to see this soon and on the final, liability without fault. You don't have to establish that the defendant intended to cause the harm. You don't even have to establish negligence. Defendant had a duty, breached that duty, yada yada. You have to establish the defendant did it, and there's a statute that says they're liable. End of story. So pit bulls are an example of that, right? We can have a debate of whether you think pit bulls are vicious or whatever. But some municipalities have passed ordinances that say you can't have them or you can have them, and if you do have them, you'll have liability for whatever they do. Period. So those jurisdictions have said, it's our opinion that these type of animals are dangerous. Maybe we even go broader than that. Dangerous animals might be wild animals. Like most jurisdictions have laws, don't keep tigers. There's people who do. I want one, yeah. It'd be cool. But it's just generally a bad idea. Even if you train them and they've been good pets, they get hungry. They do crazy things. So every once in a while you hear somebody let one loose or something happens. I shouldn't be liable. That person broke into my, or came into my house. My tiger. I didn't know my tiger's going to eat him. Doesn't matter. Yeah.
Okay. So, I was watching TV and I saw this video.
No, every story that starts with "I was watching TV."
No,
Go on.
it was a video of this guy in a Chinese zoo, and they had pandas there. Well, he sat down in front of the panda enclosure, and the panda reached through the bars and started scratching them up and all this. Would that make the zoo liable because the bear was barred?
Well, again, so let's take that scenario. I think I vaguely remember that, and go through it. Was it intentional? Probably not. They're probably not going to hold up panda liable for intentionally attacking him. Was there negligence? I mean, that would be one of the first theories, is how close did you let the public get to a dangerous animal? And maybe there's some debate of whether pandas are dangerous. I'd say they are. They look cute, but, don't go sticking your hand in there, right? So part of the theory might be, what duty do you owe patrons of a zoo? Like bars, warning, be supervising in case they get crazy, whatever. But let's say there's not that. Then what are we looking for? We're looking for a statute in that jurisdiction that says if you keep a wild animal, which I'd say a panda is, you'll have liability if they harm somebody regardless. So you take whatever safeguards you can, but there's always the risk that something could happen. I know there's a video on YouTube of that panda who freaks out because their baby sneezes or something. I know they're out of control.
So it all just depends on the laws and
I think it depends on analysis of all different types of torts it could be. And I think based on the scenario, it wasn't intentional. And you didn't give me any facts that say, somebody left a cage open, or somebody, I guess there's the argument, what if the person's poking the panda? There would be an argument that they contributed to their own harm. They shouldn't have stuck their hand in there or whatever. But, when they're saying, I'm standing there and the person or the animal, I didn't provoke them, causes me harm, then was there any negligence, or was there a statute that says we're liable? Yeah.
Well, and should the zoo even make it possible for you to stick your finger in the cage?
Right. Yeah, I think that's what it comes down to. If you sue the zoo, your theory is either there's a statute that says you're absolutely liable and it doesn't matter, or an alternative theory is you owed me a duty to prevent me from getting anywhere near where I could put my hand there, or to prevent the animal from reaching out.
But then again, it's lack of common sense to stick your finger in a bear cage, too.
if there's a sign or something.
Yeah, all those factors come into play. Like, when I go to the zoo, my kids want to ride the camel. You go around a tree, right? I know it's like $200 a kid per pop or something, but you get on the camel and you go, Dad, ride with me. Oh, great. So you get on there, and you always get the one-humped camel, and you're falling off the thing, and then you go around the tree, and they're like, you're done. What? That's what I get? Well, what if the camel gets crazy? It charges and runs out and takes off, or spits at you. I don't know what it does, but it could go crazy. So does the zoo have liability for that? I might make an argument they do. Like, there's certain liability if you're going to give rides on an animal and it turns on you or does something crazy you weren't expecting, chomps your kid. They got big teeth. Then they should be liable for that. But if they take all reasonable safeguards, I suppose there's something my kid could do they shouldn't be doing. Knowing my kids, they reached up and grabbed the thing and somewhere and yanked on it. Tail or something. Yeah, so all those facts will come into play. Where was the person at the zoo? What safeguards were taken? What are the statutes? So, does it annoy you? I never answer any question. I just say, it depends. Because it does. It does depend, right? Like, no case, if the case is already decided, go look at the case. If it hasn't been decided, then I'm going to tell you, these are all the variables, but it's not up to me. It's up to the court to decide what would happen. It'd be neat to look at some of those cases, like what liability did the zoo have? Did the jury or judge find that the zoo took all reasonable safeguards and the person was just being stupid? Or now at zoos, they make you stand behind some line because you could potentially get too close. And I think it depends on what kind of animal it is. Like camel, there's a fence there, but you can go in and ride it. Lion, there's a glass and you can't get your hand in there to feed it. Right? All right. So animals, that's one situation. Like the one that really gets people is the pit bull, right? Like, well, I heard that somebody broke into somebody's house and was bit by a pit bull and then sued the owner. Sure, that's possible. The question is, what does the statute say about what liability you have if you have a pit bull? Generally it'll say, it doesn't matter whether you said Sikkim, what's a good name for a pit bull? Fluffy, right? Or whatever. Or if the pit bull had bit anybody before. You're just liable if the pit bull snaps. Now there might be some statutory exceptions if somebody comes someplace where they're not supposed to. But if there's not, then there's no excuse. You're just liable for it. That's a tough one. You're engaged in abnormally dangerous activity. Let's say you blow things up for a living. Right? And some people do that. That'd be a fun job. But it's risky, right? And, later when somebody says my window was blown out or this flying rock did this, you're just liable. I mean, you say, well, I didn't mean for it. Doesn't matter. And then in the product liability context, which was that example over there, you make something. You don't know that the batteries are going to blow up, but they do, or they catch on fire, or something happens. You could be absolutely liable for that. Your testing never revealed it. You didn't intend to fry anybody, but it does. Yeah.
I was wondering, if you, like on a ski resort or something,
yes.
everyone who crashes and gets hurt, are you liable for all that?
I'm not going to answer your question, right? I'm going to say it depends. So let's take a look at it. No matter what scenario, throw panda bears or skis at me, I'll take you on. Is it an intentional situation? Like there was an actual case where ski resort, a guy gets on a, I don't know, what are they, double, triple black diamond or whatever, and he you'd make the argument he assumed the risk. He goes out there, and there's a warning. You got to be really good to go down this. He's not so good. He takes off down the hill. Turns out he goes to make a cut. The binding snaps, and he goes whoosh, and he's injured. What responsibility does the ski resort have in that situation? Well, what would most of you say? He was warned.
Did they try to help him?
Like how? Try to catch him while he's...
I'm saying, like, if he broke his neck and he's laying there.
Right, yeah, I didn't give any of those facts. Let's not say, like, they had a duty to kind of be out there, and he was out there for days, and no one came... Ah, now you're getting somewhere. So it turns out he rented the skis, and the person who, in discovery, remember we were talking about that, it comes out that the person who's renting the skis knew there was a defect in the binding and still rented them to him. So again, the answer is always, it depends. So you could say, guy goes down a steep hill, he was not experienced enough, shouldn't have, then he hurts himself, but you never know what turns out. And in that situation, it came out that the ski resort sues the manufacturer and says, well, yeah, we gave him the skis, but the bindings were defective. Then the manufacturer asks for the records of maintenance and shows that the person who rented out the skis made a note that there was a defect in the binding. and still renting them to this guy. So,
So I think they lost that case.
what's that? They did. I don't think the employee's working there anymore, but yeah.
Yeah, I was gonna say, and then could they try to charge the person who made note of the defect?
Sure. I mean, you might have liability because your agent, acting in their capacity as your employee, did something they shouldn't do. They were negligent, but then you could sue them. You could fire them, I guess. I mean, I'm not giving advice in that situation, but it seems like they're doing stuff they shouldn't be doing. I'm sure they were instructed not to loan out defective equipment. And yeah, you could sue and claim that the employee acted in a way which is contrary to their instructions, and they should have personal liability for that. You know, here's the short of it is, if you're an employee, and we're going to get to this more, but as an employee, you do something negligent, you have liability for that. You can't claim, well, I was doing it as an employee, or I have no liability because my employer told me to do it. So maybe your employer did tell you to do something that you shouldn't have done, but you still have liability because you did it and it was negligent. They may also have liability for it, but that doesn't get you out of it. Does that make sense? All right. Is that the last slide? Oh, no, we got Cybertorts. So the short of this is that most of the things that you could do on ground, you could do online. So could you threaten somebody over the internet? Sure. Could you, while somebody's struggling in the shower, Facebook and say something defamatory about them? Sure, you could. Could this be an online webcast? Sure. I mean, all these things could happen. I'm not sure if you shock somebody over the internet. There's that movie where anyway. So, I mean, you could do all those type of things over the internet. There are some specific issues that come up, like what liability does YouTube have for hosting videos that somebody could see and suffer emotional trauma from? Like, what if I put that video up and one of you that was my dad or something?
You're clicking on it.
What's that?
You're still clicking on it.
Yeah, I mean, I'm the one watching it, so maybe I shouldn't watch it. What liability does YouTube have? What liability does the person who posted it there have under those circumstances? Generally, I'd say, notice the ISP ones, the internet service provider, the one who's providing the internet connection, usually does not have liability for what people do over it. Like, they couldn't possibly monitor what people are using the internet for. Well, there's some technology where they could monitor some things, but the law doesn't put the burden on them to stop everything that people do through the internet. No more than it puts a burden on gun manufacturers to stop everything that somebody could do with a gun. I mean, they have to do reasonable things, but they wouldn't have to try to do everything. Right? And that could be, disclosure of private facts over the internet. There's all kinds of stories of that. A while back with, I think it was the iPhone, there was